Hi everyone. We hope that you are happy and have energy to learn today. Do you know when to file a trademark application?
The question of when to file a trademark application is an important one. Some countries have a first-to-file rule and others have a first-to-use rule. Some countries follow the first-to-use trademark system, under which marks that are actually used in commerce first are assigned trademark rights and given priority in their territory of use. Under first-to-use trademark regimes, being the first to apply for trademark registration does not guarantee priority to the applicant. If a restaurant opens on one end of the block, another restaurant can open at the other end and call itself the same name. On the contrary, most countries follow the first-to-file trademark system, under which applicants that are first to file or apply for registration of their marks are assigned trademark rights and given priority over others, regardless of actual use of the marks by applicants or existence of prior users of the same marks in commerce. In most other regions that practice first-to-file, there are varying degrees of recognition of the goodwill built up by a prior creator and user of the brand. First-to-file does not always mean that the first registrant will acquire inarguable sole rights.
Yay! In this video, we will have an insight into these two trademark systems and their application. First-to-use countries include Australia, Canada, Costa Rica, Denmark, Hong Kong, Iceland, India, Ireland, and many more. Many of these registries will have specific limitations and conditions regarding first-to-use rights. And it is virtually always the case that registration of a brand as a trademark will confer stronger and less disputable rights than relying on use in any event.
The U.S. trademark system is not an entirely first-to-use trademark system because applicants may be assigned priority based on being the first to file for registration of their marks with the U.S. Patent and Trademark Office, USTO, before they have actually used their marks in commerce.
The trademark priority rights of the first applicant to register a mark is subject to certain limitations. The trademark priority rights cannot be asserted against any other person except for a person whose mark has not been abandoned and who, prior to such filing, 1. has used the mark, 2. has filed an application to register the mark which is pending or has resulted in registration of the mark, or 3. has filed a foreign application to register the mark on the basis of which he or she has acquired a right of priority, and timely files an application to register the mark which is pending or has resulted in registration of the mark.
Nevertheless, to actually obtain trademark registration, applicants that apply for trademark registration based on intent to use must actually use the mark in commerce within a specified period of time, that is, 1. before the application is approved for publication, 2. within 6 months of the notice of allowance issue date, 3. during the extension of time obtained after the notice of allowance issue date.
We have talked about first-to-use systems, so what about first-to-file one?
A larger proportion of countries are first-to-file compared to first-to-use, and it includes Vietnam. Part of the reason for this system's worldwide adoption is probably because it is easier to administer, since it is much easier to determine the first entity to apply for trademark registration, than to determine which entity may have first used the unregistered mark in commerce, and in which geographical territories to ascertain priority. However, there are several downsides to adopting a first-to-file trademark regime that entirely disregards prior widespread international or local use of the mark in commerce by others, such as that adopted by China.
To help you better understand the trademark applications, we will discuss the case of China.
Given the importance of merely being the first to apply for registration of a trademark under Chinese law, regardless of prior use, it is no surprise that China leads the rest of the world in the number of trademark applications filed in 2018, with 7.371 million trademark applications filed, and 5.007 million approved for registration.
This prolific trademark application filings and approvals has led to widespread trademark squatting in China. Trademark squatting refers to the acts of unscrupulous entities that are the first to register marks of others, either to profit off the mark's goodwill, or to extort hefty settlement sums from the owners of the marks, when the owners want to begin using their unregistered marks in countries like China. Even well-known and world-famous companies such as Apple and Ferrari have lost trademark cases in China for using their iPhone mark and horse graphic mark, respectively, merely because trademark squatters beat them to registration in China.
Now we will come to the second case, which is about iPhone trademark in China. In 2016, Apple Incorporated has lost a dispute in China over the use of the iPhone trademark on leather products, according to official media. A Beijing court decided against the world's largest technology corporation in favor of a local enterprise. According to the Legal Daily, China's official newspaper, the Beijing Municipal High People's Court decided Zhentong Diandi can continue to use the word iPhone on its leather items. That trademarks are frequently stolen by unknown players. Some entrepreneurial businesses are eager to buy trademarks that are well known internationally but not yet registered in their own country, hoping to profit later. Registered for the iPhone trademark in China for computer hardware and software in 2002, but it wasn't authorized until 2013. In 2007, the first year that Apple's iPhone was available for purchase, Zhentong Diandi registered its trademark for leather items. Since 2012, the U.S. business has been contesting the Chinese corporation's intellectual property rights. In a previous case, Apple paid $60 million in 2012 to settle a long-running legal fight in China over the iPad trademark, which had hindered certain sales and delayed the release of a new iPad in the country. In China, Apple's second-largest market, things have.
Regardless of whether mark owners are planning to use their marks on products or services in commerce, under a first-to-use or a first-to-file trademark regimen, mark owners should always file for trademark registration as early as possible, prior to actual commercial use. Under a first-to-file system, such as in China, the first filer gets priority over prior users of the marks in commerce, even if at the time of filing, the first filer has not used the mark in commerce themselves. Under the U.S. first-to-use trademark regime, mark owners should still apply to register their marks with the U.S. DOE, prior to their actual use in commerce based on their intent to use. Under U.S. law, as explained above, the trademark application filing date is construed as constructive use of the mark. Consequently, if actual use of the mark in commerce follows within the specified amount of time, leading to subsequent registration of the mark, the applicant would prevail over other users that use the mark after their application filing date, even if such use is before the applicant's actual use in commerce. Therefore, being the first to file for trademark registration is beneficial under either system, and is a better strategy than to wait to apply for trademark registration after the mark has already been used in commerce.
That's all for today. Thanks so much for your listening.